Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you're here at this time.
Yes, Your Honor. Javar Grayson representing myself.
All right, thank you, Mr. Grayson. Good morning to you as
Good morning.
well. So, all right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Moorish American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You
Okay.
submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You tell me that the court doesn't have jurisdiction, and you're not sitting into the jurisdiction of the court. And why are you filing something in this court if you believe the court doesn't have jurisdiction? You filed
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who's representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
Well, certainly. Let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted. and that therefore the court would be required to enter their default because of their failure, things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, straight that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, no factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is a some type of traffic ticket. It started off Brian Ambrosius stopping me, and I believe I have the right to travel. It started with that, and I do understand the default judgment. What do you that you are saying, and what is pertaining to? We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiffs. And it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
All right, I got it. All right, that you failed the state of action upon which the court could grant relief. This case and the complaint in this matter be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same. But yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me. There is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides. I wish you well.
Thank you, Your Honor. Does the court be entering the order, or do you want me to submit it?
If you would submit it, Mr. Michaels, that would be helpful. I will send you a chat to address where you want to send that. And that would be helpful. So I'm chatting that to you now, sir.
All right. Thank you. Thank you, Your Honor.
Eric Martin?
Yes.
Good morning.
Good morning. Living man, will make it clear. Living man, Eric Martin, not a defendant, corporate entity.
Call case 23S00425, People State of Michigan versus Eric Martin. Allegations are that on July 11, 2023, Ypsilanti Township, Washington County, State of Michigan, on I-94 at or near Michigan Avenue, you did operate a motor vehicle at a time your driver's license was suspended or revoked. A misdemeanor carrying a maximum penalty of convicted of up to 93 days in jail, a $500 fine plus court costs, or both. Do you understand that?
Oh, I do not understand in the sense that I do not stand under the charges.
Yep. Count 2 alleges that on the same date, time, location, you did operate a motor vehicle at a time you did not have in full force in effect. Insurance is required by state law. Again, a misdemeanor carrying a maximum penalty of convicted of up to 1 year in jail, a $500 fine plus court costs, or both. And the third count alleges that on the same date, time, location, you did operate an unregistered motor vehicle. A misdemeanor carrying a maximum penalty of convicted of up to 90 days in jail, a $500 fine plus court costs, or both. These are misdemeanor charges. You have certain basic rights. You have the right to remain silent and say on the record Canada would be using it to do a trial. Court's entered not guilty pleas as all counts. The public defender will address bond in these matters.
Assistant Public Defender Lemmy Saab appearing with and on behalf of Mr. Martin, requesting a PR bond this morning, Your Honor.
Thank you.
Yeah.
I object to any representation by any attorney, as I invoke my right to Republican form of government and Republican laws under Article 4, Section 4 of the U.S. Constitution. Meaning
my phone just kicked on to where I can hear.
Hey, hang on, Mr. Mayor. I'll be with you in a minute. Okay. Court's noted the objection. The public defender is excused from proceeding further.
And that's just, yeah, not make it clear, not just as to them, nothing with them, just them specifically. I'm saying any and all attorneys, because I do not give up my right to be sovereign as one of the people, as the U.S. Supreme Court said I have as one of the people, the right to Republican form of government and to be sovereign. So that's why I say that.
Thank you.
Yep.
All right, Mr. Martin, we will set a pretrial hearing September the 14th at 9 a.m. via Zoom.
Is this so fast? Let me write. September 14th is September 14th. What time?
9 a.m.
9 a.m. And that's what's the title of that proceeding?
That'll be a pretrial hearing.
All right.
Prosecutor will be present for that hearing. We have any future filings you make with court, make sure you copy the prosecutor on. We have forwarded these for you as a courtesy, but if you make any future filings with court, including the ones you've already filed here, or in addition to the ones you've already filed, make sure you send a copy to the prosecuting attorney's office. Their address will be on the notice we'll send you, okay?
Okay, I have another objection here. I also object to a challenge of jurisdiction in this case against me as a living man.
You can make that motion in writing. Again, any motions made in writing be filed with the court and served on the prosecuting attorney's office. Okay.
Okay.
All right. Did you receive a text message to remind you about today's court date?
Did I receive a text message for what?
To remind you of today's court date.
Of today's court date? Yes, I did.
Okay. Just want to make sure you're receiving those so you're getting that notice. We'll mail them to your address on record here too as well. Okay.
Okay. Yeah.
All right.
You're
all set for today, Mr. Martin. Again, September 14th, 9 a.m. Failure to appear for a court date could result in a bench warrant for the individual's arrest. You understand that?
Well, I don't understand in the sense I do not stand under it, and I object to that because that violate my right against sovereignty and Article 4, Section 4, public and form of government, and
your objections noted.
And there's many other reasons too why I objected, because there's no jurisdiction here under many other reasons.
Well, as courts operate, you will need to file any objections in writing. I've instructed you on how to do that. So if you want to submit those objections, just write it up and make sure you send a copy to the court and to the prosecuting attorney's office so they're prepared to address that at the next court date. Okay.
Yeah. So okay. Well, one objection I kind of have with the prosecutor in the sense of, I will if I must under threat and duress. Oh, that's another thing I was going to mention. Now, I'm appearing here by special appearance, not a general appearance, and this is through threat and duress of, the rest and all that, the normal procedure that courts follow. So I just want to make that clear. I'm not really consenting to, appearing here today. I'm not consenting, for future references to be held under the jurisdiction of the court and all that. And that's one of the legal authorities I use for this is the Michigan Constitution and the U.S. Constitution under the 13th Amendment right against slavery and to not be subject to involuntary servitude. That's one of the legal authorities I rely on to be subject to any arrest for the bench warrant, like you mentioned, or anything else that's, against my will. And just want to mention that.
Okay. You've made your record on that point.
Okay. Now, what was I say about the copies of the prosecutor? Now, I will if I must under threat and duress, but see, that costs money. And I shouldn't have to spend no money for my access to the court, such as by making copies. That just costs more money for me to, make the copies. So in that sense, I'm going to ask that that the court clerk make a copy and send it to them, so I don't have to spend money to make the copies, which I think violates my right of access to the courts. And as the U.S. Supreme Court said, was it Murdoch versus Pennsylvania? I think that was one of the cases I cite dealing with my other arguments. We don't have to spend money for the exercise of a right.
But you do. You would have to. Can I address that for you, Ms. Martin? If I may, I'll address that for you. Okay.
Go ahead.
Okay. So, if there's a finding of indigency and you need to fill out a form indicating that you're indigent, so you can find that form on our website. If you file that form and there's a finding of indigency, that's easy enough for me to say, then we consider that at that point in time. Okay.
Well, I'm saying in addition, not just, I know the normal indigency is normally a thing, but I'm saying regardless of the aspect, just simply because it's a right of access to the courts, it's not just limited to indigency. It's just period. I shouldn't, don't have to pay money for the exercise of right, period, regardless whether I'm indigent or not,
I hear you, but that's a process that we have under the court rules.
Right.
Currently. If you want to challenge the court rules as they are, there's a process for that, but we have to operate with what we have to operate with right now. Okay.
Well, the court rules is, like I said, just once again, and that's the final thing to say about it is under Murdoch versus Pennsylvania, U.S. Supreme Court, and I got the volume and page and recited to already one of the papers, in general, just the right of access to, to pay money for the right, to exercise our constitutional right, no matter what constitutional right it is, you can't be charged a fee, period. So,
you made a record on that point. Like I said, there's a process for it right now that exists. If you want to challenge the processes, you'd have to, to do that. Otherwise, but So again, your next court date will be September the 14th, and we're all set for today, Mr. Martin. You have a good day.
All right.
Thank you for coming in today.
Yeah, you too. Yep, bye.